Representative Osmond has an announcement.
Thank you, Mr. Chair. I have actually 3 different people in the audience here today. First one, Matthew Feldkamp, who is my intern for the session. I don't think I've had the chance to introduce him. I also have my 2 daughters here today, Honora and Leonie, and for as long as they stick around, because they're enjoying their spring break by being dragged to the Capitol.
They're going to be here. They're going to watch this whole committee.
Long as they possibly can.
Do you want them to sit with you? We can move down a couple spots and have them sit with you if you'd like.
I thank you very much. I think that they're probably just happy right where they are.
Okay. All right. Well, guys, welcome to Commerce Committee. It's your dad's favorite committee. All right, so let's go on to the agenda. The only item on the agenda is hearing on HB 2821, and we'll get an overview of what the bill does from Reviser Reimer. Almost called you representative again.
Thank you, Chairman and members of the committee. House Bill 2821 sets up a regulatory relief division within the Office of the Attorney General, and for the purpose of establishing a regulatory sandbox program. And the point of this bill, I think, is captured in a paragraph. If you turn to page 3 and you look at the bottom of the page, the Regulatory Relief Division shall establish a program to enable a person to obtain legal protections and limited access to the market in the state to demonstrate an innovative offering without obtaining a license, certification, registration, or other authorization that might otherwise be required by state law. So what this bill does is establishes not just that, but also potential for waiver of regulations and state law that would interfere with a business that desires to come into the state and present some type of innovative offering for consumers that would be of benefit to the consumers of the state. So going back to new section 2 on the first page of the bill, this part of the bill just sets up the Regulatory Relief Division. It's established in the Office of the Attorney General. It's headed by a director who's appointed by the Attorney General, and that director reports to the Attorney General. The director may appoint staff, subject to the Attorney General's approval. And the function of this Regulatory Relief Division, among other things, is to basically administer the sandbox program and some other purposes, act as a liaison between business and agencies, review state laws for potential removal of rules and regulations that might inhibit creation or success of new businesses, and also create a framework for analyzing the risk level to the health, safety, and financial well-being of consumers with respect to repealing any state laws or repealing or waiving the requirements of rules and regulations pursuant to the program. And also propose potential reciprocity agreements there on the top of page 2. This Regulatory Relief Division is granted rule and regulation authority on page 2 and lines 15 through 21. And that authority is specified that it goes to administering the General Regulatory Sandbox Program, setting forth sandbox program application process and reporting requirements, which we will take a look at later in the bill, and consult and cooperate with other agencies in the state. Secondly, the bill creates a Regulatory Sandbox Program Advisory Committee on page 2, lines 22 to 24 there. The advisory committee has 11 members, 6 who represent business interests appointed by the director, 3 appointed by the director who represents state agencies, 1 member of the Senate appointed by the president, and 1 member of the House of Representatives appointed by the Speaker. The function of the Advisory Council is primarily to advise and make recommendations to the Regulatory Relief Division and provide assistance to the Relief Division in running this sandbox program. On the middle of page 3, you can see that the Advisory Committee is granted the authority to meet in a closed executive meeting when considering matters pertaining to applications for the program, that is, for a business that is seeking to have certain rules and regulations or statutes waived for the purposes of submitting an innovative offering for the state. There's a provision for a report on page 3 where the director of the Regulatory Relief Division is to report to the Senate Commerce Committee and the House Commerce Committee. And there's a list of information there pertaining to that report, information regarding each participant in the sandbox program, anticipated or actual cost savings that each participant experienced due to their participation, recommendations regarding any laws or rules and regulations that should be repealed or amended, information regarding outcomes for consumers, and recommendations for changes to the general regulatory sandbox program. In new section 3, there is a regulatory relief division created or rather the general regulatory sandbox program is created in the new section 3 within the regulatory relief division. And there's a list of items that the regulatory relief division is to do with respect to that program. And you can see that on the top of page 4 as well. One of those items is to reach out to businesses and provide them with information about how to apply to the program. The page 4 also sets out the application process for a business that wishes to participate in this program and obtain relief from specified rules and regulations or statutes. So you can see in the middle of page 4 there that they must present an application to the Regulatory Relief Division, and there are a number of things that that they need to provide in that application. They have to confirm that they're subject to the jurisdiction of Kansas, confirm that they've established a physical or virtual location in the state. With respect to demonstration of this innovative offering, where it will be developed, performed, and where records and documents and data will be maintained. Contain relevant personal contact information, disclose criminal convictions of the applicant or other participating personnel, if any, and of course contain a description of the innovative offering to be demonstrated. That needs to include statements regarding how the offering is subject to licensing, legal prohibition, or other authorization requirements, and also each state statute and rule and regulation that the applicant seeks to have waived or suspended while participating in the general regulatory sandbox program. That's on toward the bottom there of page 4. How the offering would benefit consumers and some other risks to consumers and some other items. The application on page 5, you can see in about the middle of the page, the application is confidential. It is not subject to provisions of the Kansas Open Records Act. After the application is filed, the process is that the Regulatory Relief Office consults with each applicable agency that regulates the applicant's business to see if more information is needed from the applicant, seeks other information from the applicant that may be necessary, and then refers the application to each applicable agency that regulates the applicant's business. So those agencies have 30 days after they receive the complete application for review to provide a written report to the director of the applicable agency's findings. And that written report is to contain at least two things. One, it has to describe any significant harm to the health, safety, or financial well-being of consumers against which the relevant law or rule or regulation protects that the applicant would like to see waived or and B, make a recommendation to the Regulatory Relief Office that the application either be admitted or denied entrance, that the applicant either be admitted or denied entrance into the general sandbox program. If the applicable agency recommends that an applicant should be denied entrance, in other words, the agency makes those findings that there would be harm to the general public, the agency is to include a description of the reasons for the recommendation, including why a temporary waiver or suspension of the relevant laws or rules and regulations is likely to significantly harm the health, safety, or financial well-being of consumers or the public and the likelihood of such harm occurring. The agency is also to consider less restrictive means for protecting the consumers instead of the regulations or statutes at issue. If the agency determines that the applicant the waiver of those rules and regulations or statutes really would harm the general public, then the agency must provide a written notice to the Regulatory Relief Office in addition to the report. So there are two things there. There's a report and the written notice. Again, not more than 30 days after the date when the applicable agency receives that application to review. The agency has to state in the notice whether it's rejecting the application on federal legal grounds. So, of course, federal law trumps state law. So, if the agency determines that a federal law is at issue, then that would be a basis for denying the business's application. Or the agency can provide notice that it seeks to reject the business's application if the approval would create a substantial risk of harm to the health or safety of the public or create unreasonable expenses for taxpayers in the state. And if the agency does that, provides the rationale, then the application would not be approved. If the agency does not go through that process, then the advisory committee that we discussed previously reviews the business's application and makes a recommendation to the director. So there's also additional procedures in reviewing that application. On page 7, the Regulatory Relief Office is to consult with each applicable agency and the advisory committee before admitting a business into this sandbox program. And there are a number of things that must be reviewed by the Regulatory Relief Office. They're on the bottom half of page 7. Adequate protection for consumers, risk of harm to consumers is outweighed by potential benefits to consumers, things like that. If the Regulatory Relief Office decides that the application should be granted, then the applicant enters into a written agreement with the Regulatory Relief Office. And that's an important part of the process. That's at the bottom of page 7. Page 8 provides some procedures for how the director may deny an application. Again, if the director would determine that it would cause a significant risk of harm to consumers or residents of Kansas, and a denial by the director is not subject to the Administrative Procedure Act or the Kansas Judicial Review Act. Another basis would be if, if an applicant has been convicted of a crime or entered a plea of nolo contendere. So that's at the top of page 8. New section 4 provides limitations on when there is an approval for the business. The business has 12 months after the application is approved to demonstrate this innovative offering that the business has described in its application. It's subject to some limitations. Each consumer must be a resident of Kansas. There are a number of other limitations there on the bottom of page 8. One important matter is, except as provided during the demonstration period, a sandbox participant shall not be subject to the enforcement of state laws or rules and regulations identified in the written agreement between the Regulatory Relief Office and the sandbox participant described. That is part of the agreement. So that's kind of also a core statement of the bill. Top of page 9, provides that the prosecutor is not to file charges for violation of a statute that's noted in the agreement. No administrative action may be taken. The middle of page 9 provides when the Regulatory Relief Office can end participation by a business, that there's no liability. The bottom of page 9 pertains to disclosures that the business must make to consumers in the process of making this innovative offering. One item of note might be the top of page 10 there. For an offering on a website or application, the consumer shall acknowledge receipt of the disclosure before any transaction may be completed. New section 6 provides the process at the end of the demonstration period, and also allows for an extension. Section 7 requires the business to retain records. There's a report required at the top of page 11 if the applicant ends the program early. The Regulatory Relief Office is to establish quarterly reporting requirements for the business that's participating in the program, and may request records, documents, data at any time. The business participating in the program is to notify the Regulatory Relief Office and each agency of any incidents that result in harm to a consumer. There's an exit report that is required after the business leaves the program, and also a report by the agency on the experience and any changes to regulation or law based on the quarterly reports or the experience of the sandbox participant, or the exit report. The Regulatory Relief Office may remove an applicant at any time. In addition, the Regulatory Relief Office is to create and maintain a website that invites residents and businesses in the state to make suggestions regarding laws and regulations that could be modified or eliminated to reduce the regulatory burden. There's quarterly reports that the Regulatory Relief Office is to compile based on those suggestions and provide that report to the governor, the Senate Standing Committee on Commerce, and the House Commerce Committee. Section 8 just modifies the open meetings law to specifically provide for a closed meeting for the purpose of the advisory committee to discuss applications. So it's a rather extensive and a very detailed process in this bill. In a nutshell, it provides an opportunity for businesses to have certain regulations and statutes waived so they can provide what the bill describes as an innovative offering to the consumers of Kansas for a limited time.
Okay, so we're going to open it for questions. Nothing like an incredibly complex bill for the last week of the year. Representative Clayton.
Well, I expect nothing less. That's what we do up here sometimes. So, looking at page 2, when it talks about people who are appointed to this committee, I noticed that we have 6 members appointed by the director, 3 members also appointed by the director that represent agencies, and then the Senate president appoints someone and the Speaker of the House. So we don't have anyone from the Senate minority or the House minority appointing anyone. So it looks like the director is appointing the bulk of people. Who is in charge of putting the director in place? All right, so the attorney general puts the director in place. All right, so I just want to make it very clear who
Is your microphone still on?
Sorry.
Yeah.
Apologize. Sorry.
That's okay. It happens. So I just wanted to be really clear here that it appears that the director is appointed by the attorney general. The director appoints 9 members, and then we get 2 other members appointed by the majority party in one chamber and the majority party in the other chamber. So that's, at least I'm interpreting this correctly.
Yes.
Got it.
I can't think of a better way to appoint a committee. Representative Osmond.
Thank you, Mr. Chair. I can, but Charles, the regulatory office is going to be under the Attorney General, correct?
Yes.
And the Attorney General is part of the executive branch, right?
Yes.
So they are doing waiving or suspension of rules and regulations, which I don't consider to be enforcement. I would think that that would be more akin to determining which laws exist or don't exist. Is that a constitutional issue? Because I would consider that more of the legislative powers.
So I guess in response to your question, I might let the conferee speak to any issues. I think this is something that has been done. I'm not sure, I haven't looked myself, but it's possible that this has been done in other states and they may speak to that. But to your direct question about does this raise an issue? So yes, there are issues pertaining to constitutionality here, but I guess I would leave it to the conferees maybe to address that, because when you talk about a legal issue, there are always 2 sides to everything.
Representative Dodson.
Thanks, Mr. Chair. When we're looking at the bottom of page 3 there, where it describes that they're going to be exempt from state laws and things like this for a certain period, then you get down into paragraph 5, and it said there still can be assessed civil penalties and criminal penalties. So is there a dichotomy there, or am I reading that incorrectly?
So I think I know to what you're referring, Representative, but would you direct me again to exactly?
So the bottom of page, I think when you started, we went to the bottom of page 3 to kind of get an understanding what the overview of the program. So that was on line 40.
Yes.
So that gives the ability to grant exceptions to state law and so on. And then now I've lost paragraph 5.
Well, there are provisions in the bill that.
It's not paragraph, I'm sorry, section 5.
Okay.
So section 5 down there near the bottom cites that both criminal and civil penalties may be assessed. This is on, let's see, it's on page 9, line 40.
Okay, so that you're referencing that the statement in the bill that the provider of the offering is not immune from civil liability for any losses or damages caused by the offering.
Correct.
Yes, so as I understand the bill, it does not protect a business from civil liability. I mean, it does protect a business from criminal liability with respect to statutes that are identified in the in the agreement, and it protects the business from any administrative action, administrative violation for rules and regulations that are identified in the agreement. But I don't believe there is protection from civil liability. And in fact, I believe that that is one of the disclosures that must be made here on. Yeah, so that's what you're referencing. This is actually a disclosure that must be made by the business. So, yes.
Okay.
I don't know if I answered your question, though.
No, I just, I think there's a little bit of a gray area in there that may have to be sorted, but I understand. I appreciate it.
All right, I'm seeing no further questions for you, sir. Thank you. Representative Poskin, sorry.
Thank you,
My
Mr.
bad.
Chair. My question might be the same question as Representative Dodd, since I was looking to see if there was any liability for the regulatory office for consumers that are injured by any laws that are waived, regulations, rules and regulations that are waived.
So, liability against the regulatory office for harm that might occur to consumers.
Mhm.
So I don't believe that that is actually addressed in the bill. There is a provision that provides the regulatory office is not liable for damages to a business because they were denied or something like that. I mean, damages in a civil action by a business. But I think the answer to your question would probably require a look at other law. And, it's possible I missed something in the bill, but I guess, the issue would be whether other law, like maybe the Tort Claims Act, would apply.
I guess that's for what my question is for the committee to consider, that if the regulatory office waives a regulation that ends up causing harm to a consumer, what is the consumer's recourse, since the business will not have been breaking the rule or regulation that they've been waived from? You see, so where do they have recourse if they're hurt by the sandbox?
So I will take a closer look at that, but so I guess fundamentally the issue you're raising is if a rule or regulation is waived and the waiver of that rule or regulation results in harm, then what is the consumer's recourse?
Perfect. Thank you. That is my question.
So, so I don't believe that the bill provides limits the liability of a business specifically. So that would sort of be a kind of something that would arise out of the, just out of the bill. And I would have to kind of take a closer look at that, but.
Okay, thank you. Please do.
I would assume that if there was negligence involved, it doesn't matter if there's a regulation or not, the business is liable. This bill does not give anybody immunity. It just waives regulations for certain businesses. If there's negligence, they're going to pay. Thank you, sir. We're going to move on to the proponent in person. And we're going to start with Representative Penn.
Thank you, Mr. Chairman. Thank you, committee, for hearing out this bill today. And Charles, you did a wonderful job. Thank you for explaining it. I respectfully brought this bill and introduced it on behalf of both the Chamber and AFP, talking about some of the things that are going on in other states that you'll hear from some of the proponent testimony here today. Because we have a landscape here in Kansas that is not conducive to businesses being started or staying. And we talk about that a lot in this committee with taxation and the like. So just to recap a few quick things, this bill was based off of, we looked at a number of different states, and you'll hear about that today. The biggest piece of this came out of the Utah version of it. And what I want to talk about very quickly, Mr. Chairman, are that this bill reviews state laws and regulations that inhibit the creation or the success of new companies and gives recommendations to the governor and the legislature about what rules and regulations probably need to be done away with that are inhibiting to that process. The Regulatory Relief Division does not have the ability to overturn or dispose of regulations. They make the recommendations to the legislature, which constitutionally has that authority, and that is not delegated. So that is not something that this does. It creates a regulatory sandbox. Folks are, if you can look at the bill, they come in and they understand what they are signing up for. And in that space is a test bed to see if businesses that are innovative and starting up in a ascribed dispensation of time, be it 12 months or 24 months if we amend that particular section of it, that they can stand up that business, see if they can operate it within that regulatory space, and then give insights as to what regulations need to be done away with by the legislature with the appropriate authority. Secondly, Mr. Chairman, it creates the framework to analyze, as I said, the health, safety, and financial risk and well-being of consumers from removing or waiving regulation. So again, is the scrutiny that we're placing on it as it proposes reciprocity agreements between the state, administers the regulatory sandbox, as you've heard before, the application of it, the reporting requirements, and so forth. It also cooperates and consults with other agencies that interact with the sandbox program. And there was a question that came up about the General Regulatory Sandbox Program Advisory Committee, consisting of 11 members, when their duties are to make those recommendations and approve the applicants and applications to the space. If you go back to the page 2, I believe it is, on the law, talks about the 6 members who represent the business interests of a variety of industries appointed by the director. I think the implication was that this is political, but I don't think that dollars have a red or blue behind them. So the lion's share of the members come from industry, 6 members. 3 members are appointed by the director, who represent the state agencies that license and regulate those businesses. So we reached out, made sure that they had a seat at the table. Actually, they have 3 seats at the table from, if you're going to go red and blue, that's from the governor's side with agencies. And then 1 member from the Senate appointed by the president of the Senate, and 1 from the House of Representatives appointed by the House of Representatives. So if you wanted to look at it through that lens, there are potentially 2 Republicans and 3 Democrats and 6 agnostic. That's the makeup. Let's see, I think there was another question that came over from Representative Dawson. Did I answer that already? Because there is no immunity from doing the wrong thing. That's written into the bill as well. So there is legal liability for those that would take advantage of consumers and that would do any criminal action as well. So it's not a get out of jail free card. And there are structures inside of the bill that if a business that applies and is in the conduct of the sandbox, if they do something awry or illegal, then there's measures that can be taken to kick them out of the program and hold them liable as well. Thank you, Mr. Chairman.
Thank you, Representative. Any questions for the representative? Seeing none, we're going to move on. Eric Stafford, Kansas Chamber.
Good afternoon, Mr. Chairman and committee members. I'm Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, and we do appreciate the work from Representative Penn and the chairman for hearing this bill today. I'll start in reverse order and answer some of the questions that were made to the revisor on the makeup of the structure of the council, where it's housed under. We're agnostic on who houses it. Utah's version is under the Department of Commerce. Department of Administration could be an option. This is drafted under the AG's office. So that portion of the bill, I think, would be open to any recommendations or comfort level from the committee. But when we first started looking into this last fall as something to consider in Kansas, and There are a handful of states: Arizona, Nevada, Wyoming, Kentucky, West Virginia, Vermont, South Dakota, Florida, and Utah, which, as Representative Penn said, this is based off of. Those states have all passed regulatory sandboxes. What made Utah different is that it is not specific to an industry. It is what they refer to as a universal sandbox. West Virginia's is specific to the financial services industry. Vermont's is specific to the insurance industry. I think same for Arizona. Arizona, I think, is financial institutions, but it's another industry specific approach. So when we first started looking into this, I thought we were talking about kind of a bill or policy sandbox really focused to help startups. Waive some regulations, waive some fees to help new entrepreneurs get their business up and running. And the reason that we were kind of latching onto that is because from the metrics we've seen in multiple studies and surveys that we've done on the competitiveness of the state from various sources, we rank poorly on our entrepreneurial climate. So that's why I was looking at how can we improve our entrepreneurial climate and started looking into these regulatory sandboxes. So then we had a call with the Office of Regulatory Relief in Utah, and I asked them, we're looking to learn more about it. And once you hear from their office what they do, it was entirely, we were going down a whole different path that that this law would allow for businesses to function in our state. So I understand the trepidation on the surface of who's liable for what's the purpose behind it. So really the concept of sandboxes started and are valuable for new and emerging markets. So some of those could be startups, some of those could be businesses. So think Uber and Lyft, right? They come up and they shake up the personal transportation services, taxis. They shake that marketplace up through innovation and technology that didn't exist before. But how are they going to be regulated when it's a new industry that we couldn't have fathomed prior to their existence? That is where they could come in and apply for that relief of regulations temporarily. This isn't a permanent thing. It's structured right now in our bill 12 months. I think Utah is 12 months, but then you can apply for another 12-month period to give you 24 months total. And so it's temporary. And when I spoke to their office this past fall, they gave an example. And they said one of our best examples that we had is a spa that was opening in our state that had hot pools and cold pools. Well, the regulatory agency overseeing them said, well, you have pools, so you need to have lifeguards on duty during hours of operation. And the owner was like, but we're a spa. We don't need lifeguards. And the agency, they applied and got a waiver to suspend the regulations that would have required them to have a lifeguard at their facility. So then they can go through and rewrite the regulations or rewrite the statute to fix the problem that was inhibiting the success of their company. So that is really a good example of what the purpose behind this law and what it serves for both consumers and businesses to be able to have a climate that fosters innovation and technological advances in new and emerging industries, but also for industries that have been in existence for a while that could be experiencing some regulatory burdens that might be an inhibitor to their business. So it is intended, again, I'll reiterate, it is intended to be a temporary relief of regulations. I appreciate the representative ranking minority members' offer on rules and regs last time on who to put in charge of that, but we would respectfully decline and look for innovative statutory ways to fix our regulatory climate, such as the sandbox proposal. So really it's a new and growing idea, but you've seen 10 or so states start looking down this path, both red and blue states. Again, this approach, we like the universal approach versus an industry specific model, but we feel like this would be a good step in Kansas to have continue to strengthen our regulatory climate in the state. So, Mr. Chairman and committee members, thank you for letting me testify today in support of this bill. I'm happy to answer any questions at the appropriate time.
All right. Yeah. Thanks for your testimony. I think you cleared up a lot of stuff there. Sorry. Christie, Representative Williams.
Thank you, Mr. Chair. So when we're thinking about something more universal, if it were something, for example, AI or something, I'm assuming that this new office would be able to exclude a participant because it's too vast, too wide, and they wouldn't allow them in the sandbox, correct?
I think that council has the discretion. And then again, you have the fallback on the state agency that if they deem it to be against, the risk of the public harm or safety could be impacted, then the agency can deny the waiver. And so the council, as it's written currently, and I think we wouldn't mind to mesh that a little bit, but the agency, if they deny that waiver request, the council cannot approve the application.
And so, for example, an emerging industry 3 years ago might have been mRNA technology for vaccines, and we have Pfizer here in Kansas. If this had been implemented prior to that, let's say prior to the mRNA being produced and in Kansas, could they have applied for that technology to be used in Kansas, or would they have been excluded just out of the gate because it's a healthcare, it has its own stream of regulation that exceeds probably what we're dealing with here? I just didn't know if there were parameters to who could out of the gate apply and qualify.
I think there are parameters. I don't know if that specific example could be applied because there was nobody saying that there were no state regulations preventing mRNA research from moving forward, right? But had there been, then yes, I think that could be an example. But I don't think you can use that as an example from 3 years ago because there was no state regulation in place in the first place, right? There was not an inhibitor, so to speak.
Just a quick follow up on that, Mr. Chair. But health regulations overall are pretty vast, and so would that just understanding that you have to go through the FDA, you have to go through these regulatory hoops, would that prohibit a company such as that today taking part in a sandbox just because there's this other federal layer?
Let me go through the language again, because I think if there's a federal layer there, I think we're just talking state regulations. We're not talking waiving of federal regulations.
And then finally, a quick last question. What would be any examples in Kansas had they had this when they came here, or perspective that you think, would be very obvious? Your Uber was a great example. The spa was a great example. I think about AI, but I'm just curious how many other states are actually utilizing it and what kind of interesting examples there might be. Thank you.
Yeah. I think your financial services industry, as that's become more tech savvy through a lot of apps, that's probably one area, which is why states have focused on that area specifically. Same for insurance as they come up with new products for consumers. But let me brainstorm a little bit on what might be out there. But I think we could always run into a spa type of situation, or a local brewery that wants to allow dogs, or something along those lines that KDHE says no, we can't allow pets at a dining establishment or whatever, and then they could make it pet friendly and have a waiver and work on the regulations. That might be kind of an example. But then, didn't you guys just pass something on pets last year? Yeah. Well, there you go. Maybe that's why that popped up to the top of my mind. Anyway, those types of ideas or concepts, if they weren't allowed explicitly through statute, that you guys have addressed. But again, I think a lot of times in this area we're dealing with the unknown, and so that the new and innovative industries that pop up that didn't exist before, eBay, any of that. So,
Mr. Chair. Sorry, I just wanted to say that I was just thinking about nursing facilities and retirement homes where pets are, I don't know, if Department of Ag allows that, but that would, I'm now seeing that there are some ways that maybe you could merge business concepts or ideas that wouldn't be potentially legal at the moment.
Yeah, and I think healthcare might be different because there are a lot of federal regulations in there, and again, I think we're only looking at the state level here, not federal. We don't have that authority, but so you'll probably run into some areas on the healthcare side because of so much federal oversight and regulation there.
Charles.
Thank you, Chairman. I just have a response to Representative Poskin's question. If you look at the bill on page 8, lines 29 to 31, it specifically states that no law or rule or regulation shall be waived or suspended if such waiver or suspension would prevent a consumer from seeking restitution in the event that the consumer is harmed. And as you pointed out, Chairman, there's nothing in the bill that prohibits civil liability.
All right, thanks for looking into that. Representative Probst.
Thank you, Mr. Chair. Thanks, Eric, for coming in today. There's a term that's used in here, innovative offering, and I'm curious, it feels like that's an open-ended term, and I'm wondering how we determine whether something is an innovative offering and who's in charge of deciding that.
Probably up to the council for determination. I mean, if that's something that wants to be defined, I don't think there'd be objection to that. I mean, again, I don't want to limit us to just innovation because there could be some regulations that could impact, like the spa example, the state regulation that, deals with lifeguards. But specific to that, I don't think, a new and emerging technology, trying to come up with some sort of definition on that would prohibit the functionality of the council or the concept by any means, if it's too vague. But again, I think this was largely drafted by and taken from Utah and applied to our laws, obviously, and specifically. But yeah, innovation is definitely a big part of it.
And you said Utah is under Commerce, under their Commerce Department?
Yes.
Okay. All right. Thank you.
Representative Dotson.
Thanks, Mr. Chair. Has Utah's bill been in existence long enough to give us any feedback?
3 years, maybe 2 years. I can't remember exactly. I would say their office was very willing. They have an office of 3 individuals. They were very eager and willing to be a source for anybody. They said if there's anything they can do to help, they're more than happy to. So I would say if any of you want to reach out, or we could have them speak to you guys at some point, but they were more than happy to be a information source and answer questions. Excuse me. Answer questions about their office and how it operates. But again, I went in very narrowly focused, entrepreneurial. This applies only to startups. And once I found out it's like any business can apply, okay, that it was really a total game changer talking to them about really what their goal is. They're trying to just be very business friendly and make sure that if businesses are encountering something that is prohibitive to the success of their business within the state, working with them through this temporary relief option to rewrite either the regulations or the statute. So that's really the ultimate goal.
Yeah, my kind of follow on here was kind of related to Representative Prost, and that is, it just would have occurred to me at the beginning that we would have put this in Commerce, and I know you're neutral on this, but the fiscal note gives 3 to the Attorney General to establish the office, and then we've got any number of advisors and so on. So I guess that would be my preference. That's just a gratuitous comment. But the other thing that came up, and I think Representative Williams touched on this, is if it's something to do with e-commerce, you mentioned eBay, for example. This is probably not something that Kansas can, or maybe even should, control. When we started some of these e-commerce businesses, they were given federal protections for some time against other rules that would have pertained to brick and mortars. So because of the kind of the federal nature of e-commerce, we probably need to be a little bit careful there.
Yes, Representative, Mr. Chairman, 100%. And I think that's where the federal, if they're regulated by the feds, there's not really much you can do. But then as you're dealing with interstate commerce, and maybe eBay is a bad example, Uber and Lyft and those that might be operating specifically, they might be operating everywhere, but specifically here within Kansas, if there's something that's prohibiting them, whether, there was the big fight, what was that, 2014, 2015-ish, the big insurance issue that the legislature dealt with on Uber and making sure that the drivers were protected. So you guys took action, but say that there was something there that was prohibiting those companies from operating successfully under a kind of a free market structure that they live by today, DoorDash, Uber Eats, those types of technologies, then those are a good example that it's specific to the state that could be prohibiting, food delivery or whatever it might be. So think of those types of examples.
Thanks very much. Thanks, Mr. Chair.
Representative Penn with the question.
More of a clarification, Mr. Chairman. Thank you. I'm looking on the Utah Legislature website, and to the conferee's point, this was actually passed by the Utah General Session 2021 by their state. And the other reason that we house it under the AG is because, as we determined in the bill, as you see, there's language talking about disputation of any issues, litigation, things of that nature, and the AG's office would automatically have that read on that vice the Commerce Secretary. Thank you, Mr. Chairman.
And there is a Rules and Regs Department under the Attorney General's office today, as they are involved in the adoption of rules and regs from state agencies reviewing for legality. And I think that was part of the factor too, since they're currently involved in the rule and reg process.
All right, seeing no further questions. Thank you very much.
Thank you.
Gannon Evans, KPI. Welcome.
There we go. Does that work? There we go. Mr. Chair, members of the committee, thank you so much for the opportunity to come out and speak in support of HB 2821 today. My name is Gannon Evans. I'm a policy analyst at Kansas Policy Institute. In front of you in my testimony, I have a lot of data and statistics about regulatory sandboxes as a whole that I'd be happy to answer questions about. But today I wanted to focus in on two examples I ran into in doing my research for testimony today. And the first is actually thinking about an interim committee hearing that was held last October, during which Representative Tarwater was also the chair. And I remember that hearing ended with discussion of finding specific regulations and bringing them to the table and having that discussion about it. So I went ahead and I went on to the Secretary of State's website and I started to read through the regulations there. And I didn't really know what I was looking for, but the thought that I left with was that it's really challenging to just go in, particularly not as an expert on these subjects or not as somebody who runs a business on these subjects, and try to make decisions, which is in part why regulatory sandboxes are so important, because it's an opportunity for businesses to come to government and say, hey, we're struggling with this regulation. Let us prove that we can accomplish the goal of the regulation, maybe without the specifics, under the guidance of a sandbox, and we can move forward from there. And my second point I wanted to bring up is a 2015 study that KPI did with Wichita State University's Hugo Wall School of Public Affairs. Unfortunately, it's not in my testimony, but I was going to send that to the committee assistant and the chair after the hearing. But what the study did is that it formed a series of focus groups with Wichita businesses, and it surveyed them about regulations, both state and local, that they dealt with. And overwhelmingly, businesses wanted to achieve the goal set out by regulations. For instance, if there were regulations that wanted to prevent a local river from being contaminated with pollution, businesses were more than willing to help achieve that goal. but they had issues with regulations being made, and they couldn't really give feedback on it in the means by which they had to follow the regulations without much assistance or maybe even the specificity of the regulations. And in part, what a regulatory sandbox would do would be to allow businesses to say, hey, we want to achieve the regulatory goals here. Let us prove to you that we could do this without these certain regulations. And it's something that offers things that these businesses in the study also listed they needed. A comprehensive review of regulations, as well as an opportunity to build relationships with the regulators they work with every day. And with that, I'd be happy to stand and answer questions.
Representative Probst.
Just thank you for your testimony today. Just playing devil's advocate here. How would legislators then be responsive to their constituents if we have this process? I mean, one of the best things we can do is listen to our constituents and then make those adjustments. Some of them have been mentioned today. If we have this system set up, we're kind of taking one of the best things about our job away from us.
I think that there's the advisory committee there with some legislative representation, and throughout the path there's many different agents involved, either through the agencies or through that. But to your point about direct legislative input into it, I'm not quite sure, and I could get back to you about that, more about the specifics, but that is a good point.
Thank you. The other point that I would make on this is I guess I'm kind of trying to figure out, we've heard a couple examples of industries that are already existing, like the spa example, I think was a good one. And then I've heard quite a bit of conversation about these are new and emerging industries, but wouldn't it be true that some of these newer industries or emerging industries, there's not regulation in effect that's affecting them? Like, we tend to be reactive to those industries, not prescriptive. We're not preemptively passing legislation that restricts an industry generally. We're waiting until there's a problem and then creating some regulation around that. So can you help me understand why this is necessary in terms of emerging industries when we typically don't preemptively regulate emerging industries? We don't even know how to regulate an industry that doesn't exist yet.
Yeah, having the sandbox in places that sometimes for an emerging industry, previous regulations may apply to that industry, and businesses and the regulatory agencies might not even realize until years into this new this new industry exists that, oh, wait, this old regulation on the book that we intended to affect businesses in this way, that maybe several decades old, is now having this effect on new businesses that operate in a similar manner. So it's more an option for regulatory review, an option for agencies and businesses to highlight issues. Specifically, what a sandbox would do is that if an emerging industry comes across regulations in this manner, they could participate in the sandbox and say, hey, here is this dated, out-of-date regulation that we've been having trouble with. Agencies, here's our feedback on how it's affecting us now. So it's more that it creates the opportunity for emerging industries to highlight some of the outdated stuff.
All right, seeing no further questions. Next up, we have Michael Austin with Americans for Prosperity. Welcome, sir.
Mr. Chair, members of the committee, thank you so much for having me here today. My name is Michael Austin, Legislative Director for Americans for Prosperity, and it is a pleasure to be here to speak on behalf of House Bill 2821 as a proponent. You've heard from many conferees on their particular perspectives on this bill and why it should be so. Me with a background as an economist, I kind of want to do what I can to give another different perspective on this bill. When it comes to dealing with new businesses as a governmental body and making sure that you, of course, maintain public health and safety, there always seems to be a bit of a schism between technological change and, I would say, organizational change. In other words, every day businesses are creating new ideas, new technology, whether that's in a new business, whether that's in a new industry, whether that's in an existing business, just providing a different service into the market. And government always has to play the role of, well, do we need to regulate this? Is there a regulation already on the books that we can apply to this? Should we honestly just leave this alone? And that type of cat and mouse game, unfortunately, creates a type of schism. In economics, we call this Martek's law, in the sense that that type of schism can unfortunately slow economic growth and can actually increase stress in the overall economy, or at least within the governmental bodies trying to find a way. And so one of the reasons why we like House Bill 2821 and this regulatory relief office and sandbox is that it creates a structure so that government doesn't have to always play catch up. Businesses can voluntarily go to this regulatory relief agency, say that the service that I'm providing or the business that I'm starting or this whole new industry that I want to kick off, right, isn't in need of having past regulations or in the need of having new regulations. And through that process, we can finally, test through a sandbox, through a structured and controlled setting, whether the services provided to consumers can be done in a safe way to see whether regulations are even needed. So the way I like to think about this is, this committee, of course, sometimes considers different tax exemptions. This is a regulatory exemption. And in particular, it's a regulatory exemption that doesn't try to say, which industry should have an exemption over another, but rather says that if you're a business that feels that you deserve one, by all means apply. Let's go through the process. Let's have a conversation through all the interested parties, and then let's make a determination. And, it just speaks to what Representative Probst, talked about, not having to be preemptive, not having to be reactive, just creating that structure that doesn't already set that boundary. As you look at the testimony that I provided to you today, there was one particular graph I hope that you might be interested in, and it looked at Kansas job formation. We're always talking about, of course, how we can grow jobs in the state of Kansas. Where does that come from? And as this committee most certainly knows, job growth comes from small businesses and comes from startups. And I think I heard the committee chair maybe a couple of years ago talk about that if it wasn't for those startups, Kansas wouldn't have any real job growth. The larger, older businesses don't grow jobs, new businesses create them. And yet, as we see in Kansas, as the Kansas Administrative Regulatory Code continues to grow, our job formation rate continues to decline. Every year, fewer and fewer jobs are created in the market because new businesses don't start up. And that's because the Kansas Administrative Regulatory Code, if you decided to dedicate a 40-hour work week to read it, it would take 4.5 weeks to get through our Kansas regulations once. Now, that doesn't mean a business has to follow every single regulation, but as the prior conferee Gannon has described, if you're not bathed in regulation, you don't know the government and industry, and you're trying to get in, you probably have to read that whole thing just to see if anything applies to you, because you don't want to find out after the fact. And so, if there's a way that we can create a process for businesses to start their goods or services in a way that is safe for consumers, but also, of course, lets them try out that innovative and possibly even start a new market, it could be an avenue for Kansas to continue to grow. So thank you so much for the time. And of course, if there are any questions or concerns, I'd love to address them.
Representative Penn.
Thank you, Mr. Chairman. Thank you, Mr. Austin, for being here today. Thank you for your testimony, and that's a really good graph right there. A couple of questions for you. Number one, to your understanding, the reading of the bill in your testimony, is there anything in here that precludes citizens, constituents from contacting the legislator about any issues that they might see or perceive happening with regulations and the stranglehold that it has?
No, so that speaks to the current status quo of how does the legislator know that there is a regulation that needs to be addressed. I don't see anything in the bill that prohibits that. At the same time, if lawmakers want to create a law to, let's say, change a regulation, this doesn't inhibit that at all. This is just a temporary exemption for a particular business on their particular good or service that they want to provide to Kansans.
Okay, and so any business that's inside of an industry that's that applies for and gets into the regulatory sandbox program, any other business like them that's already operating in the space, in the industry space, the regulations still apply to them?
That's correct.
They are not rescinded, suspended, or done away with?
Only those that apply and, of course, get approved.
Would you be amenable, or you and the other conferees, I should ask, to language saying, I've heard some discussion today about this being about innovative industries and emerging technologies, amending that language to say both common or legacy and the innovative industries.
Of course, I can't speak to the prior conferees. They can most certainly come up here, but at least as my testimony has shown today, I am not particular. I'm not particular to whether the term is innovative or emerging or whatnot. I acknowledge that this structure in and of itself can really help any business that thinks that, they can either grow a profit, better provide wages for their workers, hire more, or garner more contracts, better serve customers. By that way, I don't discriminate.
Absolutely. Mr. Chairman, if you allow me one more question. Mr. Austin, as you've read through the bill, have you seen any need for any amended language that would make you feel more comfortable with this?
We're already here as a proponent, so that says a lot in and of itself. Could I make any suggested changes? One I would is say, I believe that in the bill, it's a 12-month exemption with an extension. I think I would like to grow that to probably 24 months. The reason why is just because if you think about startups and businesses, while a lot does happen in a year, I think 2 years is probably a good middle ground in terms of making sure that any new business that pops up or new startup has enough and sufficient time to really test out their innovative process. And then, keep that 12-month extension. That's completely fine. Another one I would think of would be the fee. There's a fee that's been outlined in the bill. I think it's $250. I just want to make it clear that I think there should be some flexibility that if the body wants that fee to be completely free, I don't think government should be in a position of assessing a fee for those who want regulatory relief. So if that's what the body wants, I think having some flexibility would be nice. And then looking at the process of the approval process for regulation, there was a provision that said a state agency can, of course, deny a particular applicant. Thinking back to Representative Probst talking about wanting to make sure that this stays within a legislative body, I think I would like some sort of legislative action to be a final arbiter. So yes, you have the advisory council, yes, you have the state agency, but then I would also like the legislature to also play a role, just in case, just to make sure that we have a proper representative aspect to this bill.
Representative Kessler.
Thank you, Mr. Chair. You kind of touched on that a little bit, Michael. Thanks for being here. But I guess my heartburn on this is a little bit is that how can we keep this focused enough or narrow enough for the innovation or show the innovation of products or services? But how can we keep that? Businesses are going to probably exploit the regulatory loopholes to gain a competitive advantage over existing businesses. How can we keep that from happening?
I think that's a good question, Representative Kessler. Thank you so much. I think that can be a possibility, but then I also think that the program in and of itself is also an innovative process for the legislature or for this the Attorney General, since that's where it's housed. And I say that in this way. If you notice that a lot of businesses are applying and, let's say, getting approved for a particular service or industry and having their regulations waived, and you also notice that it's not really creating any civil harm to consumers, then that's probably an impetus for the legislative body to say, do we really need this regulation? And if that's the case, then through the normal legislative process, you can, create a law and wipe that regulation, and then create a more level playing field so that it's not determined by whoever applies through the regulatory office.
Thanks again, Mr. Chair. I personally just feel this almost goes too broad. I kind of like the idea and the concept of it. And if you were to told me you're coming in focused just on the financial institution or something like that, fintech, I'm all aboard. I'm all aboard for that. But I think now you're touching every business, every regulation, every law that we have in the state. Some that we've probably had for, many, many years. And it's just, I don't know. I think it's just way too broad. We're just not quite narrow or focused enough on this type of action, but I appreciate it.
And I appreciate your concern, Representative Kessler. I would just make one slight pushback, only to say that it's not every regulation, right? I think the bill does outline that particular regulations directly concerning the public health and safety of the consumer or the customer is still maintained. But outside of that, thank you for your opinion.
I think a good definition of innovative opportunity might help that a little bit. Representative Dodson.
Thanks, Mr. Chair. Just on your testimony, it sounds like you're suggesting that every company has to read 3.3 million words. I've started a couple companies, and maybe I didn't do my homework, but I didn't get close to the 40-hour weeks that are suggested here.
I'm sorry, Representative, was there a question?
Yeah, the question is the expectation that every startup company reads 3.3 million words?
No, the expectation was if you were to read the Kansas Regulatory Code, it would take you 4.5 work weeks to get through it. And then I further elaborated saying that while I don't expect a business, or excuse me, while I don't expect every regulation would apply to every single business, I can completely understand that if you're a new business and you may not be aware, it is possible. But no, that doesn't speak to any expectation.
Representative Probst.
Thank you, Mr. Chair. Thank you, Mr. Austin. I have a question about your chart in your testimony. It seems to clearly draw an inference that there's causation between the expansion of regulations and job formations, but I wonder if you've controlled for other variables in this. Like, do you have any idea if there was anything else going on in 2012 that prompted the creation of a lot of new businesses?
If you, thank you, Representative Probst. If you're looking into the range of the formation, it was just looking back 10 years. And
that's not my question. My question is, are you controlling for other variables?
Am I controlling for other variables? What I'm controlling, no, technically I'm not. What I'm saying is that if you can make an intuitive case as to how a regulation can impede a business, then you can also probably make the case that as regulations have increased over time, it is likely that there are at least one business that may not have started up or may not have created a job because of the extra rules that we had added onto our regulatory code.
But, okay. Yes, maybe there's one business that didn't start. That's not the point of your chart, though. Your chart is designed to show, tell me if I'm wrong, your design, and this title of it clearly states that regulations expand and businesses decrease, but you haven't accounted in this that 2012 to 2017, we had a boost in job creation because of tax code that was very favorable to LLCs. And then in 2021, we had a drop in formation because of a pandemic. Am I wrong?
I don't know. What I have said is that regulations interfere with market competition and if left unchecked, can become a barrier to startups. I believe that is true.
Okay. I'm just trying to make the point, and I think I'm right, that you're turning correlation into causation, and that's not an accurate reflection of the cause of this dynamic. There are many other things that come into the change in business form or job formation. And that, I think that's a fair statement, that it's not just regulations. You can't isolate that and say that that's the only thing that caused this change in numbers.
Representative Clayton.
Thank you, Mr. Chair. Thank you, Mr. Austin, for being here. One of the things that you mentioned was the pages and pages of regulations and how those might be outdated. And it might surprise you to hear that I do agree with you, that I think that there might be a reason why we could possibly either look at it in this committee or in an interim, or maybe have the Department of Commerce review this. But is that something that you would be up for? Because the way that I look at it is that sometimes we can go at these changes with a pair of tweezers instead of, a blowtorch. So what would your thoughts be on that, to just have the legislature or the Department of Commerce possibly look at this, or maybe even the AG's office? Why not go about it that way?
I think one of the reasons why we like this bill, obviously mentioned many reasons why we like this bill, but at least in my experience, I always knew there was always a way, or there was always an interest in finding regulations to peel back. And then the question then became, well, what regulations? And then we said, okay, well, let's have a business just make a, make a recommendation. I believe when I worked under Governor Sam Brownback, I believe he had created not much of a structure, but more just like a hotline of sorts where businesses could call in and say, hey, look at X regulation and remove that. But the feedback that we got from that wasn't really helpful to go on. This regulatory relief office, I think, is nice because it actually ties an incentive to providing a regulation that could be temporarily waived because it goes towards a business actual bottom line. If a business notices that they have to spend considerable man hours or resources just to comply with a regulation, that is an incentive in and of itself to go through this regulatory process and provide a note to the legislature whether this regulation is really needed or not.
Yeah, so you're jogging my memory on some things. So that would be the Office of the Repealer, right? That was created under Governor Brownback.
That wasn't the one I was referring to, but
okay,
that
it's
was
not the same thing. So staff, I don't know if we could look at that, but I would be curious to get information as to the effectiveness of that program, because again, I do think that there is a solution here. I just don't know if this broad of a thing is that. So thank you so much. I appreciate you being here today.
All right, we're not seeing any further questions. Thank you very much.
Thank you.
Next up is Dan Murray.
Thank you, Mr. Chairman, members of the committee. My name is Dan Murray. I'm the Kansas State Director for the National Federation of Independent Business. NFIB represents about 3,600 members from across the state. We are the voice of small business and am in strong support of this bill in bills like this. I think Mr. Stafford pointed out initially that we're not wedded to the paradigm that's established in this bill, certainly agnostic on whether it's housed with the Secretary of State, the Secretary of Ag, the homeless director and the Secretary of Commerce or the Attorney General. The point is that the issue here is the policy, and the policy is what's important. The makeup of the advisory committee is also something that we're not weighing in on necessarily. Again, the policy is what's important. When we talk to small business owners in our small business problems and priorities, most recently, the number 6 issue that confronts them is unreasonable government regulations. I think those of you around this table that have established small businesses understand there are a few things that present challenges when you do that. Finding appropriate capital to establish that business, finding the workforce that you can draw upon to help run that business, but also trying to get through the hurdles of regulations that you're confronted with. My colleagues across the country in other states support legislation like this. Missouri, Indiana, we've mentioned Utah being the first to do this in 2021. Again, I think there are ways to maybe change this legislation that reflects a honed-in piece of legislation that focuses on maybe some policy objectives that this legislature is concerned with, but the idea itself is very positive. I mentioned, I think Mr. Evans mentioned the interim committee this October. I kind of presented some general comments about the state of the small business economy, and one policy recommendation I had was this exact legislation. So I take full credit for House Bill 2821 being presented. But seriously, I referenced an effort in Missouri that was being pursued in this regard. And I think it presents a great opportunity for small business owners and entrepreneurs to seek regulatory relief in these innovative spaces where regulations, not laws, I think we're conflating some of that here today with existing statutes and laws, but being relieved of regulatory burdens that present a problem for entry into market. I will say Missouri, their legislation, and I'm not sure exactly at this day where it's at, was a 24-month relief. I think that gives you a better glide path to pursue your innovative offerings. I looked at the most recent Utah regulatory relieved entity, and it was a thing called TowPro, kind of a ride-sharing thing for tow services. But in discussions with their office, my understanding, and Mr. Stafford may have some different information, but they only have one person dedicated to this effort, and I think they share the responsibilities with other things. So in terms of 3 FTEs, I don't know if that's necessarily accurate or correct. Utah is a growing state, as big or bigger than Kansas, so I think it's a minimal impact for a very big return on the investment. So with that, Mr. Chair, I know you've heard from many others about this, and would stand and ask for your support and answer any questions you may have.
Committee, any questions? Do you have any past examples of businesses that might have developed if we didn't have regulations? I mean, Eric Stafford kind of mentioned, advocated with the Uber and bathhouse type situations. And can you touch on any other types of businesses that you've?
You put me on the spot. Certainly, I guess if a tree falls in the forest and you're not there, do you know? I think there's probably a lot of examples that we're not familiar with that went the way of the wind because they didn't get that opportunity to have those critical impeding regulations waived in the moment. A lot of startup innovative companies that have been addressed or that have met with these regulatory burdens maybe didn't get off the ground as they could. I don't have any examples offhand. I mean, I think some of the examples that we've talked about, some of these ride sharing things, the gig economy things that are out there are certainly some of those. And depending on how this committee decides to either broaden or shrink the scope of this legislation would impact the number of kinds of bills or businesses that could be included or excluded from the regulatory relief proposed. That's a good non-answer.
Oh, yeah, sure was. It was a long one too. Thanks.
I know. You're
all
welcome. Right. That's the beauty of going last here.
Well, okay, that's it. That's all I have. Thank you very much. And no more questions. I don't have any other proponents in person. We do have a couple of written. One is a proponent, an opponent, and one is a neutral. But I do not have anyone in person that's an opponent. Is there any opponents here? I'm not seeing any. We do have one neutral that's online, and we save our onlines for last, and we only get to them if we have time. It looks like we might have a minute or two if we could bring them on. Reese, MP?
Yes, am I coming through okay?
You are.
Chair Tarwater and members of the committee, thank you for the opportunity to provide neutral testimony today. My name is Reese Empey, and I'm the Senior Director of State Government Affairs at Libertas Institute, a nonprofit think tank based in Utah. And regulatory sandboxes are something we've worked extensively on inside and outside of Utah. Now, I'm going to avoid any redundancy and simply give the history and overview of sandboxes around the world, as well as here in the United States. This concept isn't new, beginning in 2016 when the United Kingdom launched the world's first sandbox and targeted financial technologies, or fintech. Shortly after, several other countries began implementing sandboxes of their own while expanding the concept to other industries. Stateside, in 2018, Arizona passed the United States' first sandbox, which also targeted fintech, and something similar began to happen. States such as North Carolina, Hawaii, Connecticut, Vermont, Utah, Kentucky, and several others began implementing sandboxes of their own while expanding the concept's application to other industries with strong bipartisan support. For example, some industries that have been targeted and explored on top of fintech include healthcare, insurance, agriculture, energy, salmon recovery, and others. In total, there are 14 states currently running sandboxes of some kind, and only 12 states that have yet to consider a sandbox of some kind. On that note, this bill would establish a universal rather than a targeted sandbox that's open to most industries rather than simply targeting one or two, which allows for innovative trials to take place across multiple industries, and it's open to everyone. If this bill is signed into law, Kansas would become the 4th state to establish a universal sandbox. Arizona, Utah, and Kentucky are the other 3, with Arizona and Kentucky also housing their programs in the Attorney General's office, while Utah houses their program in the Governor's Office of Economic Development. These 3 states initially had targeted sandboxes and expanded them to be universal because they'd have to turn away applicants if they touched industries outside of the sandbox's scope. In other words, they received applications that touched multiple industries and had to reject them as a result. Also, if it's helpful, Hawaii's financial technology sandbox is the only state I'm aware of across the country that houses its sandbox in commerce. In Utah, specifically, we established the sandbox outside of any regulatory agency because we wanted it to be independent, which also makes potential applicants much more comfortable in approaching the sandbox. It's also worth noting that there's a universal sandbox moving through Missouri right now. Oklahoma considered a universal sandbox last year, and Nebraska considered a universal sandbox a couple of years ago, but ultimately passed an insurance sandbox. A sandbox invites the business community to the table to highlight troublesome rules and regulations, show through a trial that those rules and regulations aren't working as intended, so that the state can reform or repeal those, and in the end, the state becomes better welcoming to the innovations of tomorrow. At Libertas, this is something we've worked on in Utah since 2019, starting with the FinTech Sandbox and later establishing the country's first universal sandbox in 2021. And I know the folks in Utah are excited to see more states consider similar programs as well as different ways to apply the concept. Thank you for your time, and I'd be happy to answer any questions.
I'm not seeing any questions. Thank you very much for your testimony, and sorry to make you wait so long. I am not seeing anyone else here to testify on this bill, and so I'm going to close the hearing on this bill. We're not going to work any bills today because we are overtime, and so we